Hello everyone, welcome back to our channel. Now we are discussing an interesting subject, deemed dividend. Telangana High Court judgment in Prasad Film Laboratories Pvt Limited versus ACIT regarding Section 2, subsection 22E, deemed dividend. High Court clarifies business payments not taxable. Welcome to today's detailed legal analysis. In this video, we will explore the landmark Telangana High Court judgment in Prasad Film Laboratories Pvt Limited versus ACIT. In a case that provides a significant clarity on Section 2, subsection 22E of the Income Tax Act 1961, commonly referred to the deemed dividend provision. This case reaffirms that commercial business payments through running accounts do not attract tax as deemed dividends. We'll see the background of the case. Prasad Film Laboratories Pvt Limited, a closely held company, filed appeal against common ITAT order dated 14th March 2007 for the financial year 2003-2004 and 2004-2005 and 5-6. So the assessing officer had classified regular payments made by the assessee to its parent company as a loans and advances. Loans are advances, invoking section 2, subsection 22E, and taxed them as a deemed dividend. So ITAT appealed this bill and remanded the matter for computation based on daily balances. The company challenged this demand before the Telangana High Court. Then the legal issue was the central issue before the High Court was, can payments made in the ordinary course of business through a running account be treated as loans or advances under Section 2, subsection 22E? This was the question before High Court. Section 2, subsection 22E says, we will see the legal provision. Let's read the key extract of this section. Dividend includes any payment by company not being a company in which the public are substantially interested of any sum by way of advances or loan to a shareholder holding not less than 10% of voting power, a concern in which such shareholder has substantial interest to the extent of accumulated profits. This is the key portion in the section regarding dividend. So the purpose is to prevent tax avoidance via disguised dividends. But does this apply to normal business transactions? So the fact of the case, the assessee made payments to its parent company during regular business operations. These were routed through a running account without any interest or repayment obligation. The ITAT accepted the business nature but still upheld the taxability under Section 2, subsection 22E, citing the legal fiction. So the assessee's arguments, the counsel for the assessee argued, one is it's a commercial nature, the second is running account, third is the legal misapplication. Commercial nature, these were genuine trade transactions and not intended as a loans. These are not intended as loans. These are genuine trade transactions. Second is a running account. Options of obligation to repay, hence not a loan or advances. Legal misapplication. ITAT misapplied legal fiction and ignored the substance of the transactions. This was the argument of the Council of the Assessing. These are the arguments. So the High Court observations reliance on Raj Kumar, Delhi High Court 2009 case, advance must involve a repayment obligation. Business transactions are not advances under Section 222E. And there is a circular, CBDT Circular 19/2017. Trade advances in commercial transactions are not deemed dividends. Trade advances in commercial transactions. So CBDT advised officers not to file or pursue appeals on such matters. No loan is equal to no deemed dividend. Citing creative dying and ambassador travels cases, commercial payments through current accounts are not covered by deemed dividend provisions. And fourth one, the appeal maintainable despite remand action. So citing Supreme Court and Allahabad High Court, even if ITAT's remand order was accepted upon, assessee's appeal remains valid. So the purpose of Section 2, subsection 22E intended to prevent disguised distribution of profits, not to penalize regular business dealings between related parties. And key precedent cited CIT versus Raj Kumar, Delhi High Court 2009, and CIT versus Creative Dyeing Printing, Delhi High Court, and CIT versus Ambassador Travels Pvt Limited, Delhi High Court, and CIT versus Arvind Kumar J, Delhi High Court, and CIT versus Atul Engineering, Allahabad High Court, CIT versus Amrit Singh, ANH High Court, affirmed by Supreme Court, and CBDT Circular number 19/2017. Clause 3 of the circular states that the trade advances, which are in the nature of the commercial transactions, would not fall within the ambit of the word advances in Section 2, subsection 22E. Hence, the department officers are not to pursue such cases further. To those already filed should be withdrawn. So the final judgments. So these are all the Supreme Court, the High Court observations. These are all the court's observations. And the final judgment, the High Court set aside the ITAT order, ruled in favor of the assessees, holding the business payments are not loans or advances. Business payments are not loans or advances. Such payments do not qualify as deemed dividend. So consequential assessment orders based on the remand were rendered void. So the conclusion is Section 2, subsection 22E should not be invoked in normal intercompany trade payments. Courts consistently apply the substance over from the doctrine, and CBDT Circular 19/2017 is binding and in favor of assessees. Always analyze business realities, not just book entries. We have two channels, RR Corporates. Other channel, RR Legal Talks. Subscribe and hit the bell icon so that you will not miss any of our latest videos. Thank you.